All right, let's dive right in. If you're staring down the barrel of the bar exams, you know that jurisdiction is everything. I mean, get it wrong, and your case is over before it even begins. So today, we're going to absolutely nail the original jurisdiction of the Federal Court of Australia. Let's do this.
So, I want to start with a question. The one question that you need to have tattooed on the inside of your brain every time you see a problem question about the federal court. What is the single most important rule of its original jurisdiction? And there it is. The answer is that simple and it's that absolute. It is always statutory. The federal court has zero power, no authority whatsoever to hear a case unless a specific act of parliament gives it that power. This is the bedrock. Everything else we talk about is built on this one idea. And that idea leads us straight to the front door of the federal court, which for our purposes is Section 19 of the Federal Court of Australia Act 1976. This is the gateway you have to get through. Okay, now look closely at the wording here, because what Section 19 doesn't do is just as important as what it does. Section 19, subsection 1, says jurisdiction is vested in it by laws made by the Parliament. See? Section 19 itself doesn't just throw the doors open. It's more like a locked gate. You need another law, a totally separate act, say the Competition and Consumer Act or the Corporations Act, to come along with the key and actually unlock it for your specific case.
And this is the huge difference you've got to remember for the exams. State Supreme Courts, they have what we call inherent or unlimited jurisdiction. They can basically hear anything unless a law specifically tells them they can't. The federal court is the complete opposite. It's a creature of statute. It can only hear a case if a law specifically says it can't. It's a fundamental distinction.
So if a statute gives the court jurisdiction, what does that jurisdiction actually attach to? Well, the answer is a really important constitutional concept called the matter. The matter is the whole shebang, the entire actual fight between the parties. It's not just the slice of it that's about federal law. It's the whole dispute. Now, this comes from Chapter 3 of the Constitution, and it has to be a judiciable controversy. All that means is it has to be a real dispute with real consequences. The court isn't there to answer hypotheticals or give friendly advice. So you're in an exam. How do you spot if a matter arises under federal law? Well, here's your cheat sheet. You look at the documents, the pleadings. Is the actual cause of action created by a Commonwealth law? Is the right someone's trying to enforce based on a Commonwealth law? Heck, is even the defense based on a federal statute? If you can tick any of these boxes, you've got your federal hook. Okay, that naturally leads to a really common scenario. What happens when you have one big dispute that has a federal claim, but it's all mixed up with, say, a common law breach of contract claim? Well, this is where a brilliant concept called accrued jurisdiction comes into play. Accrued jurisdiction is basically the court's power to say, you know what, once a real federal issue gets this case through my door, I'm going to deal with the whole thing. It can grab the entire controversy, including all the attached non-federal bits like common law or state law claims, as long as they all mash together to form one single matter. The big test for this comes from a case called Fencott v. Muller. It's the common substratum of facts test. The easiest way to think about it is this. Your federal claim is the invited guest to the party at the federal court. The attached non-federal claims are its plus one. As long as they're part of the same story, the same common set of facts, they get to come to the party too. And here is an absolutely crucial tip for your exams. Do not forget this. Even if that federal claim, the one that got you in the door, ends up failing, the court still has jurisdiction to decide the rest of the non-federal claims. Once the whole matter is in, it's in. The party doesn't stop just because the original guest has to leave early. Okay, last up, let's clear up something that trips up so many students, this idea of inherent versus implied power. Where does the court get its power to manage its own business, like stopping someone from abusing the process?
Let's be crystal clear on this, because it's a classic trap. The federal court does not have inherent jurisdiction. That's a term you say for courts like the state Supreme Courts, these superior courts of unlimited jurisdiction.
So what does it have? It has powers that are implied by a statute or incidental to the jurisdiction it's been given. Think of it like this. Inherent jurisdiction is like owning the entire workshop. Implied power is more like being given a very specific statutory toolbox. The court can't build whatever it wants, but it has all the necessary tools in that box to do the job that Parliament has given it. It's a power to manage the cases it's allowed to hear, not a source of power to hear new ones. Okay, that was a lot, I know.
So let's boil it all down into a dead simple practical checklist that you can run through every single time you're faced with a federal court jurisdiction problem. Right, here it is. Step 1, the gateway. Find the specific act that opens the Section 19 gate. Step 2, the matter. Define the single controversy. Does it arise under that federal law? Step 3, accrued claims. Are there any non-federal plus ones hanging around that share a common substratum of facts? And finally, step 4, the power. Is the court using an express statutory power or one of those implied tools from its toolbox? And that's it. That framework is your key. It doesn't just tell you if you're in the right playground, it defines the very boundaries of the fight you're about to have. So the question I'll leave you with is this. Now that you know the rules of the game, how does that change your opening move?